1020 life refers to the sentencing structure in the state of Florida for certain firearm offenses. There are 3, 10, 20, and 25 to life year minimum mandatories for certain firearm offenses in the state of Florida. For example, if you have a prior felony conviction and you're found to actually possess a firearm, you would have to serve a minimum mandatory sentence of 3 years in prison. Likewise, if you were involved in a car burglary and during the commission of that car burglary you possessed a firearm, there would be a 3-year minimum mandatory sentence. And if you were convicted of an aggravated assault using a firearm or having a firearm when you place the person in fear, there would also be a 3-year minimum mandatory sentence with very limited exceptions. If you actually possess a firearm during many crimes like robbery or rape or burglary or attempted murder or aggravated battery, there is a 10-year minimum mandatory sentence for just actually possessing that firearm. If you discharge the firearm during the commission of those crimes, then there is a 20-year minimum mandatory sentence. And if you discharge the firearm and cause great bodily harm or death, then there is a 25 to life minimum mandatory sentence, meaning the judge has to give you at least 25 years minimum mandatory, but can give you anywhere from 25 to life as far as that minimum mandatory is concerned. And of course, the prosecutor is the only one that can waive this minimum mandatory sentence. The judge can't. Or if you're found not guilty of the underlying offense, or you're found not to have possessed the actually possessed the firearm, then you also would not be subject to these minimum mandatory sentences.